as soon as we can. Thank you, folks. All right. Good morning again. How are you?
I'm good. How are you?
I'm well, thanks. All right. Your juror, let me just verify your juror number. You're in seat 55, your juror 807.
Correct.
Is that correct? All right. All right, ma'am, you said that you've heard about Mr. Lloyd's case.
I have.
Can you tell me how you've heard about it?
I didn't remember the date exactly, but you said it was January 2017. At that time, I was a travel nurse, and I was living in New York, and I was visiting my mother for about a month or two when that all was unfolding.
Okay.
So I was staying with her, and she always has the news on, so I did see pretty much everything unfold, on the news.
Okay.
And I was watching throughout, the week when they were looking for him.
And did you also talk to your mom about what you were seeing?
At the time, yeah.
Yeah. Okay. Since that time, have you watched any coverage or seen anything?
I feel like it's been a while since things were out in the news up until, recently when they were talking about the jury being selected.
Did you read any of the articles that were published right before jury selection or look at the news?
No.
And you said you had formed an opinion as to Mr. Lloyd's guilt. Is that correct?
Correct.
And what is your opinion?
That he committed the crime.
Okay. Jurors have to be able to presume him to be innocent until and if the state can prove he's guilty beyond a reasonable doubt.
Correct.
And let me tell you that we're not looking for one answer or another. There are no right or wrong answers to these questions. We just need you to tell us the truth. Do you believe that you could presume him to be innocent, or are you pretty much convinced he's guilty?
Correct. I believe he's guilty.
I'm sorry?
I believe he's guilty.
All right. State?
State moved, Your Honor.
Defense? All right. Thank you, ma'am. I don't think this is the case for you, but we appreciate your willingness to serve. You are discharged as a juror and free to go.
Thank you.
Who did I just excuse? All right. So let's just go back to the beginning. Let's go to juror number 44, or I'm sorry, juror in seat 44, number 277. Morning.
Good morning.
How are you doing?
Good. How are you?
Just well, thank you. Okay, a few questions for you. You've heard about the case, correct?
Yes.
How have you heard about it?
I only recently, beginning of this year, moved to Florida. I was living in New York. That's where my family is from. And at the time, my sister has been down here for about 10 years, and she is a former NYPD officer. So when this case happened, it struck a nerve with her, so she told me about it.
Okay. How long did your sister serve with the NYPD?
10 years.
Did you and she used to talk about her job?
No, she didn't really talk about it that much. She had a lot of, tough situations, and she is permanently disabled because of the job.
Because of her job?
Yeah.
Was she involved, was she injured?
Yes.
And was she injured?
In an altercation with a suspect.
Okay. This case involves the shooting of a law enforcement officer. Do you believe that you would be able to be fair and impartial to both sides?
I think it would be a little difficult for me.
Okay. Did you form any opinion? I take it you and your sister talked about this case.
Yeah, when it started coming back up in the news that things were happening, that this was going to be coming up,
Okay.
She did start mentioning it to me, and I do watch the news in the morning, so I did see the preliminary information. So, and then when I got my jury notice, she was like, I hope, that you're not on that case because I know it's going to be difficult for you.
Okay. Well, did you form an opinion as to whether or not Mr. Lloyd is guilty?
I don't know if I've formed an opinion, but I know that being from a law enforcement family, I can't say it sways, but it does make a difference to me, and especially since my sister has been disabled because of an altercation.
State.
State moves, Your Honor.
All right, ma'am, this isn't the case for you. We appreciate your willingness to serve. I hope your sister is feeling okay. Thank you, ma'am. You're free to go.
Thank you.
Next up, we have the juror in seat 46. Good morning.
Good morning, Your Honor.
How are you doing?
We're doing well, thank you.
Okay. All right, let me start by asking you, I know that you indicated you knew something about this case, but let me start by asking you some different questions, which is this. You had indicated you had some doctor's appointments with the VA.
Yes, ma'am.
And you were having. When are those again?
The sleep study is the 3rd and 4th of November.
Okay.
I have a hematology on the 20th of this month and a preceding phlebotomy before that.
Okay. And do you have any issues with sitting on a case like this for 3 weeks?
No, ma'am.
Okay. Are all of these appointments things that you could reschedule? Or do you need to go to any of them?
The only one that has really concern for me and my doctor is
The one on November 3rd and 4th?
Yes, ma'am.
Okay. And I remember talking to you about this on Friday, about your sleep apnea. Some folks, their sleep apnea causes them to just fall asleep suddenly. Like sitting at a traffic light, they just fall asleep. Is your condition that?
That's the way it used to be before I underwent CPAP therapy.
Okay.
Right now, they said that they've done as much as they can with tweaking the machine, and they're looking at a possible, I think he called it a central sleep apnea. Some doctor term that it goes outside of the normal breathing restrictions.
Okay. Is there anything about that condition that would affect your ability to sit in court and listen to the testimony? I mean, we normally go about an hour to an hour and a half before we'll take a break, but it's sitting in those chairs, listening to witnesses and, looking at whatever evidence, physical evidence is introduced. Can you do that?
As I said Friday, I'm kind of active, so sitting very long is not really part of my daily, but I do notice in the evening when I do sit down to watch TV or something, I will find myself nodding off at that time.
Okay. You also have heard something about this case. What have you heard?
Ma'am, it was just what was reported in the news.
Okay, can you tell me how much of the news you watched?
I just knew that there was an incident, police shooting. There was an apprehended, and I lost interest after that.
Okay. Anything about what you heard, or, well, let me ask you one other question. Have you ever talked about this case with other people, just in passing, just chatted about it?
No, ma'am.
Okay. Is there anything about what you heard that caused you to form an opinion about whether or not Mr. Lloyd is guilty?
Yes, ma'am, I believe there could be an instance or two that was may cause me to preclude my decision.
Okay. So by that, do you mean that you think he's guilty? You think he's probably guilty? Help me out here. What are you thinking?
Based on what I've heard, I would say that he's probably guilty. I'm not going to say yes, but probably.
Okay. So the law requires jurors to be able to presume him to be innocent until the state proves he's guilty beyond a reasonable doubt. It's not his job to prove he's innocent. So based on what you just asked me, let me give you a couple scenarios. You tell me if any of them apply to you. If you were seated as a juror, would you start the trial believing, this guy's probably guilty, but I'm willing to listen and see if I'm right? This guy's guilty and he needs to prove to me he isn't. Or he's innocent, I don't think he did anything until and if the state proves to me he did. Any of those three apply?
Right now, I would think that
That he's probably guilty, but you're willing to listen?
yes, ma'am.
All right, thank you, sir. State. All right, sir, because of that, we appreciate your willingness to serve, but I don't believe you meet the standard for this case of presuming him innocent. And I can't tell you how much I appreciate your honesty. We all do. So you're discharged as a juror in this case. Good luck with your sleep apnea test. All right,
ma'am.
thanks. Juror in seat 48, please. Good morning.
Good morning, ma'am.
How are you doing? I'm okay. All right. Got a few questions for you. Let me start with, you said you'd heard something about this case.
Yes, ma'am.
All right. What have you heard?
When it first happened, I would hear about it like at work, people talking about it like in team meetings. When I worked, we had work hours from 6 in the morning to 4 in the afternoon. So our supervisor and other coworkers would say things like, just make sure you have good situational awareness.
Okay, you're going to need to speak up a little because now I'm having.
I apologize.
That's all right.
Our coworkers would say like, make sure you have good situational awareness because at the time I believe it was a manhunt and they were looking for Mr. Lloyd. So they just say, be aware of your surroundings. And I think once he was apprehended, they told us, hey, you can stand down, everything's okay, but that was the base of it.
Okay. So during that time that they told you to be aware of your surroundings and all of that, were you fearful?
No, ma'am, because at that time, I was still new to the area, so I wasn't familiar with where it took place in relation to where I was. So I didn't think that I was like near the area that was involved.
Okay. So did you follow the news coverage on the case?
I would see the notifications like on the phone, but I didn't read into it because I felt that I wasn't in the area that it involved, so I didn't pay attention.
So you didn't watch it on the news or read about it? You read the notifications?
I would see the notification, but I don't read all notifications that come up.
Right. So did you watch the local news at all?
No, ma'am, I don't watch local news.
Did you read anything in the newspaper, the internet, Facebook, anything like that?
No, ma'am.
Right. And once Mr. Lloyd was arrested, did you ever discuss it again?
I don't believe that we or I intentionally engaged in a conversation about it. Once we were told to stand down, I felt okay.
Okay. Based on what happened back then, and people talking to you about the case, did you form any opinion as to whether or not Mr. Lloyd was guilty?
No, ma'am, because I didn't have any information on it.
All right, the law requires you to be able to sit here today and presume Mr. Lloyd to be innocent. Can you do that?
Yes, ma'am.
Okay. So let me talk to you a little bit about the death penalty. What is your position on the death penalty, ma'am?
It's my opinion that it's a tool that the state has at its disposal
Okay?
to impose it needs to be considered very carefully. And it would be a lot of factors that would go into asking for something like that.
Right, so do you have any religious or moral objections to the death penalty?
No, ma'am.
And are you someone who believes that there are types of cases where the death penalty should automatically be imposed?
No, ma'am, not automatically.
Okay. That is Florida law. There is no automatic death sentence in the state of Florida, okay? So let me explain a little bit more about if you got to a penalty phase, okay?
Yes, ma'am.
What you would have to do as a juror. It's almost like another trial. The state is going to present evidence of the aggravating factors. And as I explained to you, aggravating factors are reasons why the state believes it's appropriate for a death sentence to be imposed in this case. The defense then presents their mitigators. Mitigating factors are reasons they believe that a life sentence without the possibility of parole is the appropriate sentence. So you listen to all of that evidence. I give you the jury instructions, which is the law that you're required to follow on this. You then go back into that jury room where you've been waiting. You go with your fellow jurors. You guys can discuss it as much or as little as you want. You're free to discuss anything, but you do have to be able to weigh those aggravating factors and mitigating factors. Decide how much importance you personally give to each one. You can consider all the evidence in the case and the facts and those aggravating factors and mitigating factors. And as I said, you all are free to discuss it. We don't have nothing to do with what goes on in that jury room, as long as you all want to talk about it, okay? But in the end, it's an individual decision for you.
Yes, ma'am.
And so after you had looked at everything, weighed out all the factors, aggravating or mitigating, if you believed that the appropriate sentence was life without the possibility of parole, could you impose that sentence? Could you vote for that?
I could, ma'am.
All right. If at the same time, at the end of all of that, you believed that the appropriate sentence was death, would you be able to vote for that?
If I felt that that was what was warranted, yes, ma'am.
Okay. Moving on to the insanity defense. As I told you, Mr. Lloyd has raised the defense of insanity. The defense has to, it's the only thing they have to prove. They have to prove that by clear and convincing evidence in the guilt phase of the trial. We're just talking about guilt phase now, when you're trying to decide whether or not he's guilty. If at the end of all of the evidence in the guilt phase, you felt that they had proved it, would you be able to return a verdict in this case of not guilty by reason of insanity?
If I felt that what they presented warranted that, yes, ma'am.
All right. And then lastly, as I told you, he's been convicted of the murder of Sade Dixon and her unborn child and sentenced to life in prison on that. Is there anything about that fact that would weigh in your mind? Actually, strike that. Can you follow my instruction about not using that in the guilt phase of the case?
Yes, ma'am.
Can you put it aside?
Yes, ma'am.
Do you think it would be weighing on your mind during guilt?
No, ma'am.
All right, because you can't use it during guilt. All right. Thank you very much, ma'am. I don't have any other questions for you, but the attorneys do state you may inquire. Mr. Buxton? Oh, it's perfect.
Good morning, ma'am.
Good morning, sir.
When you were talking with the judge earlier, you said you heard about the case when it happened and talked about it with your coworkers and supervisor.
In meetings, yes, sir.
Okay. Did you hear any of the details of the actual event?
No, sir. What it was like if we had like a team meeting, it would be people like to the side, up in sidebar conversations.
Okay.
And our supervisor as a whole would say, to the crowd or to everybody there, make sure you maintain good situational awareness. Don't go get gas like at 0 dark 30 or, something like that.
Okay, so you heard about, you were aware of the generalities, but not the specific details. Am I correct about that?
That's correct, sir.
Okay. And I believe you said when your supervisor, when he was apprehended, your supervisor said, okay, it's okay, you can kind of go back to your
Yes, sir.
normal life. Did you hear any of the details of the apprehension, or just that he was apprehended?
No, sir, just that he was apprehended.
Okay. Based on your answers to the judge's questions a few minutes ago, it sounds like you're kind of neutral about the death penalty.
I would say I am neutral, yes, sir. It's a tool.
Okay. And on a scale of 1 to 10, 1 meaning that you would never vote for the death penalty regardless of the situation, 10 meaning you would always vote for the death penalty in any first-degree murder case, where would you fall in that spectrum?
I would have to sit at a 5, sir, until I hear everything.
Right down the middle?
Yes, sir.
All right. And I believe you indicated that you believe in the fact that there is no automatic death penalty in the state of Florida. Just because someone commits a first-degree murder, regardless of how bad that murder is or what the facts of it, there shouldn't be an automatic death penalty. Do you agree with that?
I agree with that, sir.
As the judge briefly indicated, if we get to that point in this trial, the state will present evidence of aggravating factors, which are factors that make this murder more egregious than other murders. Would you be able to listen to those aggravating factors, and regardless of how many aggravating factors are presented to you, how bad the evidence is to make this murder egregious, would you be able to hold off judgment until you hear evidence of mitigating circumstances?
Yes, sir, I would need that.
Okay. Regarding the mitigating circumstances, or those circumstances in which that might make this murder the proper punishment be life, this isn't the time to talk about the details or the facts surrounding the aggravating factors or the mitigating circumstances. That'll be during the trial. But would you be able to listen to any mitigating evidence presented to you, digest and analyze the evidence, and then only after analyzing that evidence, then come to a decision about the proper punishment?
Yes, sir.
Would you be able to do that regardless of what mitigating circumstances presented to you?
Yes, sir.
Do you think Mr. Lloyd deserves to have a jury who is open-minded and would consider any and all mitigating evidence presented?
Yes, sir, he does.
Okay. Once you hear the evidence about the aggravating factors and the mitigating circumstances, you have a few options as far as what to do with that evidence. You could find that the evidence didn't prove the aggravating factor or the mitigating circumstance, or you could find that the evidence did prove it, but this piece of evidence really isn't important in my decision-making process. I don't give it much weight. Or you could say that this piece of evidence is really important in my decision-making process and give it a lot of weight. It's up to you to decide how much importance to give a certain factor. Does that make sense?
Yes, it does.
Okay. Once you get that information and you start assigning weight to these things, then your analysis is going to be, do the aggravating factors outweigh the mitigating circumstances? If you find that, then you are authorized to vote for the death penalty in this case. That make sense?
Yes, it does, sir.
Now, as the judge indicated, that the decision about what the proper punishment in this case is yours and yours alone. It's an individual decision. And if one person decides that the death penalty is not appropriate, that life in prison is the proper punishment, that's the sentence that gets imposed.
Yes, sir.
It would take all of you to come back and all unanimously vote the death penalty is the proper punishment for that sentence to be a potential sentence in this case. You understand that?
Yes, sir, I do.
Okay. And nothing ever requires you to vote for death.
Yes, sir.
All right. Looking into your heart and soul, and not talking about a situation where you're hanging out with your coworkers, talking about a case, thinking, yeah, I could vote for death in that case. I would think that person deserves death. In the real life situation, would you be able to, in the jury room, after you hear all the evidence, if you felt that death was the proper punishment in this case, come back in here and tell the judge that, and render a decision saying that this man deserves to die for his actions?
If what I was presented to use to make a decision warranted that, yes, sir, I would.
Okay. One of the issues in this case, as the judge indicated, is an insanity defense, which obviously plays into a mental illness issue. And forgive me for asking a few personal questions, but I think you realize why I kind of have to ask a few of those.
Yes, sir.
Has mental illness or mental health issues affected you or a close family member or a close friend?
Yes, sir, relatives.
Okay, and can you tell me, not the name of the person, but kind of the relationship of the person to you?
You say the relationship without the name?
Yeah, I don't need to know, I don't want to ask the specific name, but is it a friend, a family member?
A family member, sir.
Okay. Did that family member get any help or treatment for that issue?
Yes, sir.
Okay. So I would gather that if it's have you seen that family member go through the issues that he or she went through?
Yes, sir.
Based on that, I'm gathering that you believe that mental illness is actually a real thing.
Yes, sir, I believe that.
Okay. Did that, after that, I'll strike that, would you be able to listen to all of the evidence surrounding the insanity defense, specifically in the mental health issue and the ramifications of that if the mental health issue exists, and wait till you hear all that evidence before you make a decision as far as whether insanity has been proven?
Yes, sir.
Okay. Is there anything in your life or your background that jumps out in your mind that might make you think you wouldn't be a good juror for this type of a case?
No, sir.
Great. Okay.
Did she serve active duty in the Navy? Sounds like she did. That's true.
I noticed on your jury questionnaire that your previous employer was the Naval Air Warfare Center.
Yes, sir.
What is that? What did you do for that in that position?
I was a business financial manager.
And what did that involve on a day-to-day basis?
It was accounting. If a program needed funding for a trainer that they were trying to build or that was being sold, I was the person who would coordinate the funding for the parts, make sure that the contractors or the government officials got paid or that they had funding available for them.
Okay. Was that a civilian position or did you serve in the military, as active military?
Both, sir. I was active duty military.
I see.
But that job was as a civilian.
Okay. What branch were you?
Marine, sir.
Okay. Thank you for your service, ma'am.
Thank you, sir. My pleasure.
No other questions, Your Honor.
Thank you, Mr. Buxton. Mr. Lenneman, you may inquire.
Good morning, ma'am. How are you?
Morning, sir. I'm well, and you?
So when did you serve in the Marines?
Sir, from July of 1989 until December of 2010.
Okay. So you did a couple tours?
I went to Iraq once, sir.
Okay. Now, Mr. Buxman spent a lot of time talking about the rules in regards to the penalty phase. Do you have any questions about those?
No, sir, not at this time.
Okay. So essentially, I just want to make sure you understand that the way the legislator created the decision-making process of the death penalty is that they were sure to make it mandatory that each individual juror gets to decide whether to vote for life or death individually through their own weighing process. They don't have to get around the table and talk about it. It's all up to you individually. Do you understand that?
Yes, sir, I do.
Okay. And the law says, I don't think Mr. Buxman, I think he did mention it actually. The law says that even if you find the aggravating circumstances outweigh the mitigating circumstances, you are never required to vote for death. You may have some reason, whether it's mercy or something else, but you are never required to vote for death. Do you understand that?
Yes, I do, sir.
Okay. And finally, if you are, this requires a unanimous jury, that means all 12 have to vote for death. If one person votes for life, that's considered a life verdict. You understand that?
Yes, sir.
Okay. And finally, do you understand that there may be an occasion, there has in the past, on certain kinds of cases where a juror will be not in agreement with your opinion, and sometimes people get pushy and try to kind of persuade other jurors of their opinion. If you have a firm opinion in your belief, will you allow that to happen?
For someone to make my opinion theirs?
To bully them, for them to bully you into saying, okay, you're saying X, well, let me tell you why, this is why, and blah, 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 and you have a firm opinion one way or the other, life or death. Are you going to let anybody change your opinion?
No, sir.
Okay, thank you very much.
Thank you, sir.
Either side need to approach?
No, Your Honor.
No, Judge.
All right, ma'am. We're going to bring you back for one final round of questioning, and it will be the final round. Can you hear me with this phone?
Yes, ma'am, I can.
Okay. We will be picking the jury the next time that you come to court. I'm going to change your color to purple. You're now a purple dot. And that's just because when you're calling the jury room to find out when you're supposed to come back, you're listening for the purple group.
Yes, ma'am.
Okay? We're giving you a sequestration package. The jury will be chosen the next time you're here, and they will be immediately sequestered. So you need to pack a suitcase, bring it with you to jury selection. Bring it with you to jury selection, but leave it in your car. You'll only need it if you're actually selected as a juror.
Yes, ma'am.
There's a slip of paper in there with the phone number that you're supposed to call. Don't even start calling until Friday after 5, this Friday after 5. Then call Friday, Monday, Tuesday. We won't need you earlier than next week, and it'll probably be towards the latter part of the week.
Yes, ma'am.
But just call after 5, and eventually you're going to hear the purple dots to report on such and such a time. It will be this courtroom, but you'll be reporting to the jury room. Okay?
Yes, ma'am.
Do you have any questions?
No, ma'am.
All right. Thank you so much, ma'am. We appreciate your time this morning. Yes,
Thank you,
ma'am.
ma'am.
You're free to go. All right, the juror in seat number 49, please. Good morning.
Good morning.
Can you hear me through this mask?
Yes.
Can you hear me? Okay. If at any point you can't, let me know. All right? So, just like I said, we have a few questions for you. There aren't any wrong or right answers to these questions. There's just what you actually think and feel. So just be honest with us, and you'll be doing exactly what you're supposed to be doing. Let me start with, you said you had heard something about this case. Is that right?
On the TV, I just heard about it on TV.
Okay, you're going to need to get that mic closer to you because I can't hear you.
I said I see the act on the TV, that's it.
You saw it on television?
Yeah, well, when it was happening.
Okay, how much did, it's okay that you saw it on TV. How much did you see?
How much?
How much did you see?
No, I see when the incident was happening and what happened.
Okay,
Everything they
can
used
you
to show on the
loosen your
TV.
mask a little bit?
Everything they used to show on the TV, that's all I see.
Okay. Did you see a lot of it? Did you watch it every day? What?
No, not really watch it every day.
Okay. Based on what you saw on TV, did you form an opinion as to whether or not Mr. Lloyd is guilty?
For me, what he's doing, it was bad, but from my concern, my religious, I cannot judge someone to say if it's guilty or not guilty, because I don't know when the person doing the act, what was happened to him spiritually.
Okay.
That's why I cannot really decide about cases.
So if I understood you correctly, you said what he did was bad, but your religion prevents you from judging someone?
Yes, that's correct.
Okay. So what religion are you, ma'am?
I'm Pentecostal.
Are you a Pentecostal?
Yes.
All right. State.
Statement, Your Honor.
Any objection? I can't hear a word you're saying.
Just one or two questions.
Sure, go ahead.
How are you doing, ma'am?
I'm okay. I'm okay.
So the way a trial works is there's a possibility that there will be kind of two separate trials in this case. One has to do with the guilt or innocence of Mr. Lloyd in regards to what he's accused of doing. The state would put on evidence, I would put on evidence, and at the end of that, you as a juror would have to decide whether he was guilty or not guilty. Can you do that?
No, I cannot punish someone guilty or not guilty.
Thank you, ma'am.
All right, any objections? Mr. Lenneman, any objection? Okay. All right, thank you, ma'am. Based on your religious beliefs, I'm going to excuse you from this jury, but thank you for coming in. You have a good day.
Thank you. Thank you.
The juror in seat number 50. All right, good morning, sir. How are you?
Good morning, ma'am.
All right, just have a few questions for you.
Okay.
As much as possible, try to relax. Can you hear me with this mask on?
Yeah, I
Okay.
can hear you.
There aren't any right or wrong answers to the questions we're asking you. There's just what you actually think and feel. That's all we're looking for. So don't worry
ma'am.
about what the answer is. Just be honest with us. So let me start with, you said you'd heard something about this case. Can you tell me what you heard?
All I heard is, I watched the case, pieces of it when it first came out, and I don't really follow it, but I've seen different news on it sometimes, and maybe we discuss it with my wife or so, and saying that well, we don't know the reason why he did what he did. It could be insane, it could be. So that's pretty much what I know about it.
All right. Based on what you've seen, have you formed an opinion as to whether or not Mr. Lloyd is guilty?
Well, I thought about it. I said, if he's crazy, I don't know if it's the right word to use, say that he's crazy, and, I have a brother that is mentally ill, and, I know he had put our family in situation already, but I said, I don't know what's the reason why he do what he do, so
Okay.
I don't really judge him unless I really see what he really do.
Okay. So does that mean jurors have to be able to presume he's innocent until and if the state can prove he's guilty? Can you do that?
I don't know. I've never been in this situation where I have to say, okay, I judge somebody unless I know on the other side hear from the other side what he do.
Okay. Maybe I'm not making myself clear. In a criminal case,
Yes, ma'am.
defendants are presumed to be innocent until the state can prove they're guilty beyond a reasonable doubt.
Okay.
You follow me so far?
Yes, ma'am.
So as you sit here today, can you presume Mr. Lloyd to be innocent
Yes, ma'am.
until you hear the evidence, and if it convinces you he's guilty? But it has to be based on the evidence you hear in the courtroom. Can you do that?
Well, I believe he's innocent, and yes, I believe he's innocent until, but I know you say it's up to base on the evidence in court, but I don't know. I have to hear both sides of the case and see if he's really innocent or guilty.
Okay. Can you tell me, have you ever thought about the death penalty before?
Yeah, I thought about it, but between me and my religion, I don't really believe in the death penalty.
Okay.
I know I couldn't find somebody guilty on the death penalty because with my religion and I never believe it. I raised up in a Pentecostal church, and I, never believe in it.
So you're Pentecostal?
Yes, ma'am.
So based on your religion, are you someone who could never impose a death sentence regardless of what the law says?
Yes, ma'am.
All right. State.
Statement, Your Honor.
Mr. Lenneman?
Just a couple of questions, Judge.
Sure.
How are you doing, sir?
Doing okay, sir. Good morning.
So the law basically says that if you were a juror on a case like this where the death penalty is being sought, that you have to have the ability to at least consider the death penalty to be able to sit on the jury. If you can never consider the death penalty in any form or fashion, then you can't sit on the jury. The law also says that you are never required to vote for death under any circumstances. But that doesn't mean you can sit on the jury if you can't follow the law. And one of the pieces of the law is to consider the death penalty. Consider death, consider life, and make an ultimate decision. Are you following me?
So far?
Okay. So you have these moral beliefs, right?
Yes, sir.
And you are part of, the state of Florida as a citizen who has civic responsibilities.
Yes, sir.
One of the things as civic responsibilities is jury duty and to participate in the system that is lawful in the state of Florida. You follow me?
Mm-hmm.
Okay. So is your belief so strong about never voting for the death penalty or not being able to find someone guilty because the death penalty is at play that you would disregard your civic duty in making a decision?
That's really a trick question, because I don't want to disregard my civil duty, and at the same time, I don't want to go against my religion, my belief, But, I've been with this religion from ever since birth, and I believe that, I just never want to find myself in the position where I have to decide between life and death of somebody.
Okay, I understand that. So I guess my question is your belief so strong that it's going to overcome anything else, including your civic duty?
Objection to formally question.
Sustained.
Okay.
Sir, you don't need to answer that question. Rephrase it.
Knowing what I have told you, are you going to be able to sit on the jury and keep an open mind in spite of your religious belief?
If I'm on the jury, I know I'm not gonna consider the death penalty.
Okay. Thank you, sir. I appreciate it.
All right, any objections, Mr. Linneman?
No.
All right, thank you, sir. Based on your religious beliefs, this is not the case for you, but we appreciate you coming down. You're excused.
Thank you, ma'am.
Juror in seat 51, please. What we got? Okay, we're going to take a break after this, juror. Okay. Good morning, ma'am.
Good morning.
Can you hear me with this mask on?
Yeah, I can hear you.
Okay, if at any time you can't, let me know, all right? All right, ma'am, we just have a few questions for you. There are no right or wrong answers to these questions. We're not looking for a particular answer. We need you to be honest with us, so don't worry about what your answer is, just be honest with us, okay? Let me start with, you indicated that you've heard something about this case. Can you tell me what?
It was on the news.
Okay, so how much of the news did you watch?
I don't watch that much of news, but that day it was a big impact, and I just heard it.
All right, so that day, what do you mean by that day?
Well, the day it was on the news.
The day it happened? Okay.
Yeah.
So other than that day, did you watch any more news coverage?
Yeah, because I work late, and, you know, not only that, in the news, you can hear other people talking about it.
Okay.
So that's how I know.
How much talking about it did you hear?
Not a lot.
Not a lot?
Not a lot.
Okay. Before you came to jury, to this courthouse, when was the last time you heard anything about this case?
The day I heard it, that was the last day.
All right. And based on that, did you form an opinion as to whether or not Mr. Lloyd is guilty?
I would say not.
Okay. So can you presume him to be innocent until and if the state proves he's guilty?
Well, that I can't, because the reason I said he's not is because I don't know that day if he was going to anxiety, depression, or mental sickness. And my moral religious, I cannot prove him guilty.
All right, so what religion are you?
I am Baptist.
You're Baptist? Mm-hmm. All right, are you saying that your religion prevents you from sitting in judgment on someone?
Yeah. I not 100% know it, but I know, I believe on the death, the resurrection, and the judgment. And I know from there, I know that one person.
All right, so do you believe that your job as a juror is this, okay? If you're a juror on a case, you, in the guilt phase, you have to listen to the evidence that's presented. You have to have an open mind, and you need to listen until the very end of the case, all right? So at the end of that case, you would be asked to make a decision based on the law that I give you as to whether or not the state has proven that Mr. Lloyd is guilty beyond a reasonable doubt, or whether Mr. Lloyd has proven by clear and convincing evidence that he was insane at the time of the offense. You follow me so far? All right. So if at the end of all of this, you had heard all the evidence and you believed that the state had proven that Mr. Lloyd was guilty, could you render a verdict of guilty?
No, because I believe on forgiveness.
Okay. And if you believed, well, actually, I don't have any other questions. State?
State moved, Your Honor.
Defense? Sure. We have one more. Okay, who is it?
How are you, ma'am?
52, yeah.
Hi.
Okay. So I understand that you have very strong religious beliefs. And you're aware that, or you agree with me that you have certain responsibilities as a citizen of the state of Florida and living in Orlando as a law-abiding citizen. You agree with that?
Yes, I do.
Okay. So one of the responsibilities is coming in to do jury duty, okay? And serving on a jury if you're qualified, okay? And on the other side, you have a strong religious belief.
Yes, sir.
And I think you said it was not judging someone.
Yeah.
Is that correct?
Yes.
So in a situation where your responsibility was to listen to all the evidence in the first part of the case, because you had said you thought, well, maybe there was something wrong with him, okay? In this case, we're putting forward evidence that there was something wrong, that Mr. Lloyd was insane at the time of this incident, okay? So that would be one of your responsibilities to judge that, okay? So would you be able to listen to the state's evidence fairly and to judge the insanity defense fairly and keep an open mind? And at the end of that, make a decision to determine whether Mr. Lloyd is not guilty by reason of insanity or guilty?
Yeah, I will listen to the case. If you guys go into a medically proven that he was not having a sickness, mental sickness, or a depression, or anything like that. That's the only way I would find him guilty.
Okay, so if we put on evidence that he does have that, and you don't believe it, you don't believe he's mentally sick, you would be able to find him guilty because we didn't prove that, and the state proved their case. You'd be able to do that, right?
Yeah, the only way is the case, is the state just like testing his ability mentally.
Okay.
He was not sick.
Okay.
That's the only way I would
Okay.
find the case.
Okay, and so you would be able to find him guilty if that wasn't proven to you about the insanity issue, right?
Yeah.
And you would be able to find him guilty if the state proved to you beyond a reasonable doubt that he did this. Okay,
Yeah.
thank you.
All right, so let me follow up on what you said. You understand that the state does not have to prove that he's not insane. The defense has to prove he's insane by clear and convincing evidence. Do you understand that they have to prove the insanity, not the state? You understand what I just said?
I'm a little bit confused because I don't speak English very good.
Okay.
Yeah, I have a little problem understanding that when there's a lot of confusion. So
Let me take my mask off to make sure you can hear me clearly. The defense of insanity has to be proven by the defense, by clear and convincing evidence.
Mm-hmm.
It's not the state's job to prove that he's sane. It's the defense's job to prove he's insane. Can you follow that?
So you say it's not the state job, it's the defense job.
The insanity, all right? The insanity defense has to be proven by the defense. So the state's going to stand up and they're going to present evidence that they believe proves that Mr. Lloyd is guilty of the crimes he was charged with. And you have to decide, did they prove that beyond a reasonable doubt? And I'll give you the definition of beyond a reasonable doubt. The defense is going to stand up and say, he was insane at the time, but it's their job to prove he was insane. Can you follow that?
No.
Is it that you don't understand the English, or you just don't understand the way I'm explaining it?
I just don't understand it.
Okay.
That's the first time I ever be involved in something like that. To be honest with you, I don't want to be like bringing up something and then that's not right. Because I do not understand, what is reasonable doubt is, and that's my confusion right there. Reasonable doubt.
Let me see the attorneys at the bench, please. All right. I'm going to ask you a few more questions, okay?
Okay.
I know that's not thrilling for you, but I'm going to ask you a few more questions, okay? Let me ask you about your beliefs about the death penalty. Can you tell me what those are?
Death penalty?
Yeah, the death penalty.
Yeah, when you put somebody to sleep?
The death penalty in Florida is by lethal injection. My question is, let me put it another way. Do you have a moral or religious objection to the death penalty?
My suggestion is forgiveness. Forgive.
I'm sorry, I can't hear you. You've got to have the mic next to your mouth. What-
Forgiving.
You believe in forgiving.
Yes, ma'am.
Okay. Does that mean that you have an objection to the death penalty?
Yeah.
Okay. Like I told you, you don't need to hesitate about your answers. You tell us what you actually believe.
Yes.
All right? All right. So, if you found yourself in a penalty phase in this case, Mr. Lloyd had been convicted, you have to be able, you never have to vote for death, but you have to be able to consider death as an option. Would you even consider the death penalty as an option? Or would you automatically vote for life?
Yeah, I would vote for life.
You would what?
I would vote for life.
You would vote for life
Yeah.
without considering death.
Yeah.
All right.
State vote, Your Honor.
All right. Thank you, ma'am. We appreciate your time and your willingness to come down here. You're excused as a juror in this case.
Thank you.
Thank you. Juror in seat 52, and this is the final one from 9 o'clock. The other two got moved into the 10:30 group. Good morning.
Morning.
Can you hear me through this mask?
Yes, ma'am.
All right. If at any point you can't, let me know, okay? Just have a few questions for you. Not looking for any particular answer. There really aren't any right or wrong answers to these questions. We just need you to tell us the truth, what you honestly think and feel, okay?
Yes.
Just to verify, you haven't heard anything about this case before you came to court, is that correct?
No, Judge.
All right. So, do you have any religious or moral objections to the death penalty?
No.
Are you a person that believes that if someone is convicted of first-degree murder, premeditated murder, that they should be automatically sentenced to death?
No.
The law in the state of Florida is very clear. There is no automatic death sentence in a first-degree murder case. In fact, the automatic sentence is life without the possibility of parole, unless and if the state can prove aggravators that a jury believes are sufficient to impose the death penalty. Follow me so far?
Yes, Judge.
Okay. In a case like this, the penalty phase is a second trial, basically. The state's going to put on evidence of the aggravators, why they believe the sentence should be death. The defense is going to put on mitigators, why they believe the sentence should be life without parole. I give you the law. The jury instructions are the law that you're supposed to follow. You and your fellow jurors go back in that jury room. We have nothing to do with what goes on in the jury room, okay? You all can discuss it, not discuss it. It's up to you. But you can discuss it if you want. But you personally have got to weigh the aggravators that you feel were proved and the mitigators. You have to weigh them and give them whatever weight you think they deserve. You've got to weigh that out, think about the evidence, the facts, either talk to or not talk to your fellow jurors, And in the end, you have to make a decision as to whether you think life or death is the appropriate sentence. So if at the end of all of that, you felt that life without parole was the appropriate sentence, could you vote for that?
Yes.
And if at the end of that, you felt death was the appropriate sentence, could you vote for that?
I'm not sure.
Okay. What is it that's causing you to hesitate?
I just don't have an answer at this time.
Okay. Is it the enormity of the responsibility of that vote that's causing you to pause? Okay. Because you told me you didn't have an objection to the death penalty. It's just the thought of you being the one to have to do it. Is that correct? Okay. What about the insanity defense? Mr. Lloyd has raised the defense of insanity in this case. If at the, and that would be in the guilt phase, when you're trying to determine whether or not he's guilty. The burden is on the defense. It's the only time it's their burden. It's by clear and convincing evidence. If at the end of the guilt phase of the case, you felt that they had proven that he was insane at the time of the crime, would you be able to return a verdict of not guilty by reason of insanity?
Yes.
Okay, and then the last question I have for you is, you remember I told you that he's been convicted of the murder of Miss Dixon and her unborn child and sentenced to life in prison. You cannot use that to decide whether or not he's guilty of these charges. It's a completely separate case. Do you understand that?
Yes, yes.
Can you follow that instruction and put it out of your mind in the guilt phase?
Yes.
All right, thank you, sir. I don't have any other questions for you, but the attorneys do. Mr. Paxman, you may inquire.
Good morning, sir.
Good morning to you.
A few minutes ago, you indicated to the judge that you couldn't give an answer as far as whether you would be able to actually make that vote for the death penalty. Did I understand you correctly?
Yes.
Okay. What's going through your mind? What's the, is it a religious issue, a moral issue, or an issue that you don't know if looking inside yourself, if you would be able to actually raise your hand and say, I think this person deserves to die for what he did? Is that the burden on your personally?
I believe so.
Okay. Can you think of any situation where, after listening to all the facts and all the evidence of the aggravating factors and the mitigating circumstances, can you envision yourself, not in a hypothetical sense, talking to friends, coworkers, and family, but actually sitting in a jury room after considering the evidence, raising your hand and saying, the death penalty is appropriate and you voting for it? Do you have a doubt in your mind you could do that? And it's okay if you do.
No.
No, you know what?
Can you ask the question again?
Sure. Do you have any hesitation that if you were back in the jury room after listening to all the details and the facts and evidence, would you personally be able to vote for death in any circumstance?
Objection is an improper question.
Can you rephrase the question?
Yes, ma'am. If you find yourself back in the jury room and you've heard all the evidence in this case, you've considered the evidence of the aggravating factors and the mitigating factors, would you ever be able to come into the courtroom and vote and say, this man deserves to die for what he did? Would you be able to be a part of that process?
Okay, I can only have one lawyer objecting. Mr. Lenneman started. Nope, you started. You have to finish. Go ahead.
Also a brief commitment, Judge.
Let me look at the question again. Hold on. Overruled.
Looking inside yourself, knowing you better than anybody else, would you be able to do that?
Yes.
So by your answer, I'm understanding that if you analyzed the evidence and you felt that death was the proper punishment in this case, you could vote for death.
Yes.
Okay. Is there any reasonable doubt in your mind that you may not be able to?
No.
Okay. Can you talk to me a little bit more about the struggle that you went through in coming to that decision?
I believe that if the verdict is, or my decision is death, I mean, that's final.
On a scale of 1 to 10, 1 meaning that you would never vote for death, ever, no matter what the circumstances are, and 10 being you'd always vote for death for any first-degree murder case that you would look at, where would you fall on that spectrum, that line?
Between the 7 and 8?
Between the 7 and 8?
Yes.
Meaning
Yes.
most of the time you would vote for death?
Yes.
Okay. The judge indicated a few minutes ago, I think she talked to you about this, that in Florida there was no such thing as an automatic death penalty. You agree with that?
Yes.
What would happen is the state would present evidence of aggravating circumstances, which are facts that make this murder more egregious than other murders. And no matter what the circumstances of the murder, no matter how many aggravating circumstances are presented to you or how bad those aggravating circumstances make this murder, would you still be able to listen to mitigating evidence presented to you?
Yes.
Okay. And would you be able to hold off judgment about the validity of those aggravating factors and mitigating circumstances until you hear all the evidence surrounding them?
Yes.
Once that evidence is presented to you, you have the option to do a few things with it. You can look at the evidence as it applies to an aggravating factor or a mitigating circumstance and say, look, the evidence just didn't prove those existed. That's one option. Another option is you could look at it and say, well, the evidence has proven those things exist, but this aggravating factor or mitigating circumstances really isn't important in my decision-making process as far as what the proper sentence should be, so I'm not going to give it much weight or importance. Or you could say this piece of evidence is really important in my decision-making process and give it a lot more weight or importance. Does that make sense?
Yes.
All right. Would you be able to go through that analysis and that weighing process?
Yes.
And once you go through that weighing process, then the ultimate decision is to be made. You individually make the decision of what the proper punishment should be. If you're never required to vote for death, the law is never going to say if you check these boxes and all these boxes are checked, you have to vote for death. You understand that?
Correct.
Okay. If one juror votes that life is the appropriate sentence in this case, that's what sentence will be imposed. Okay?
Yes.
It would require all 12 jurors to come back and vote for the death penalty for that to be a potential sentence in this case. Does that make sense?
Yes.
Now, knowing that you never have to vote for death, and knowing that if the jury unanimously comes to the conclusion that the death penalty is the proper punishment in this case, everyone will know you voted for it, obviously, right?
Yes.
Knowing that, I'm going to ask you just one last time, knowing that you never have to vote for death and that everyone would know you did, in fact, vote for death if it was a unanimous verdict, do you still think you'd be able to sign that paper or raise your hand and say, I vote for death?
Overruled.
Can you repeat that question?
Sure. Knowing that you never have to vote for death, and knowing that if the jury does unanimously vote for death, that everyone would know you did it, would you still be able to, in that jury room, raise your hand and say, that man deserves to die for what he did?
Yes.
If you believe that was the proper punishment?
Yes.
Okay. Is there anything in your life or background that makes you feel you may not be a good juror for this type of a case?
I don't recall that.
Okay. One of the issues in this case is insanity, and that comes into play some mental health issues. I'm going to ask you a couple personal questions, and forgive me. But do you or a close friend or family member have ever dealt with any kind of mental health issue that affected your life or their lives?
No, sir.
No?
That's a no.
Okay. Some people say or think that mental health issues are fake, they don't exist. Do you believe that mental health issues are real and legitimate in society?
Yes.
Okay. Would you be able to listen to all the facts of the case surrounding the insanity defense and whether a mental health issue exists, and if so, what the ramifications of that issue are before making a decision as far as whether insanity has been proven?
Yes.
Okay. So you can reserve judgment until you hear all the evidence?
Correct.
All right. One last question. I noticed in your jury questionnaire your occupation was a manufacturer engineer.
That's correct.
What do you do on a daily basis? What's that involve?
In my current position, I work in the clean technology. I work for Siemens, and the work includes building the structure for what we call the nacelle or the turbine. It's a tower.
You said building the structure for what we call
A nacelle.
okay.
That's the turbine. And that includes fabrication, of course, to make the structure, then painting it to keep its lifespan for over 25 years. And of course, the internals for you to get up in the tower and all the power that brings it from the nacelle to the grid.
Okay. Thank you for that explanation. I appreciate it, sir. No further questions, Chairman.
Thank you, Mr. Bruxman. Mr. Lenneman, you may inquire. You started, you have to finish, okay? Sure.
Thank you, Judge. How are you doing, sir?
I'm doing fine.
I'm just going to talk to you about a couple of things, and then we'll be done. So Mr. Bruxman covered some of these, and I just want to make sure you understand what the rules are when it comes to the second part of the case if we get there, all right? So the only way we're going to get to the second part of the case, which is the penalty phase, is if Mr. Lloyd is convicted of first-degree murder of Sergeant Clayton, okay? You follow me on that?
Yes.
Okay. So your responsibility then as a juror is there's going to be like a second trial. The state's going to put on evidence. The defense is going to put on evidence. They're going to put on aggravators. We're going to put on mitigators. And then after all that, we'll do closing arguments and give you our position on why they believe the death penalty is appropriate and why we believe it is not. Once you hear that information, as jurors, you go back, and the first thing you have to do is make a decision as a group, and this is the only time you do anything as a group. Make a decision as a group, first individually, whether you believe one or more aggravating factors were proven. If you believe that, and collectively each one of the jurors believe that, then you can go on to the next step. You follow me?
Correct.
So the next step is individual. Everything after this point is individual. The jury instructions in the law will make it clear that this is an individual decision by you. You're the one who makes the final decision whether to vote for life or death. There's some guidance on how you should do it, but it's only guidance because the law says you are never under any circumstances required to vote for death. And when the judge instructs you on that, that's exactly what she's going to tell you. But the guidance is this. Once you guys prove one aggravator beyond a reasonable doubt unanimously, then you have to look at the aggravation the state presents. You have to decide whether it was proven beyond a reasonable doubt. They may give you a number of different, what they call aggravating factors. You have to look at each of them, decide whether it's proven beyond a reasonable doubt. Then you have to decide, when we present the mitigation to you, you have to look at that mitigation and say whether it was proven. It's a lesser standard than reasonable doubt. It's a lower standard, but it still has to be proven. Once the mitigation is proven to you, then you have to weigh the mitigation and the mitigating factors. You may find one that is very, very weighty for you. You may find some that are in the middle range and some are in the low range, but you get to decide how much weight you give each individual mitigator. You also get to decide how much weight you give the mitigation collectively. Then you look back at the aggravation and you have to do the same. Weigh each one, how much weight, collectively how much. Once that's done, then you basically have two things, mitigation and aggravation. It's your responsibility then to weigh those factors and decide which one weighs heavier in your mind. If you believe the mitigation outweighs the aggravation, then the law says you must vote for life, period. There's no ifs, ands, or buts. If the aggravation in your mind outweighs the mitigation, the law says you may, M-A-Y, may vote for death, but you're never required to. Because as I told you earlier, there's a provision that the legislator has put in that says, listen, folks, you as jurors make the ultimate decision. We know death is a serious, serious thing to decide, and we're never going to force you to make a decision. So we're going to always give you a way out. And it could be for anything. You could have a moral reason, you can have another reason, but you never have to vote for death. So even if you feel the aggravators outweigh the mitigators, you never have to vote for death, period. Do you understand that?
Yes, sir.
Then collectively, you will get together as a group and you will cast your votes. In order for a death vote to take place, it has to be unanimous. Every juror on the panel, all 12, have to vote for death. If one juror votes for life, it's a life verdict. Not a death verdict, it's a life verdict. So all it takes is one juror to vote for life. Do you understand that?
Yes, sir.
Okay. So one other thing I wanted to talk to you about, and I don't think this is obviously going to be a problem with you, because I don't think you're a person who's meek or you're going to allow yourself to be pushed around. But there are circumstances in the jury room that will develop sometimes because this is such a serious case and there's a lot of emotion connected to it. Some of it's anger, some of it's other things, but sometimes jurors try to push other jurors into changing their decision. If you have a firm position and stance on your belief, one way or the other, are you going to maintain it?
Yes, sir.
Okay, you're not going to let anybody bully you.
No.
Okay. And if you see someone else being bullied, are you going to mention that, listen, we're not supposed to do that. Everyone has their own decision. Let a person make their decision.
Are you asking me if I would be making the call?
Not making the call. If you're the type of person...
Sir, you need to put that mic up to your mouth. I can't hear you. Not you, Mr. Lenneman.
Oh, sorry.
That's all right.
I'm not saying making a call. I'm just asking you, if you saw a circumstance that you thought was wrong going on in the jury room, would you say something?
Yes.
Okay. Those are all the questions I have. Thank you very much, sir.
Thank you, sir.
Thank you, folks. Anybody need to approach?
No.
All right, sir. We're going to send you through to a final round of questioning. The next time you come, we will be picking the jury that day. So I have a couple of instructions for you. First of all, you're now a purple dot, not a green dot. And that's just because when you call the jury room line that we're going to give you, you're listening for purple dots return on this date at this time. I have no idea what day it is yet because I don't have enough folks to know that. It'll be no sooner than next week. So start calling this Friday after 5. So call Friday, call Monday. Eventually, you're going to hear the call back. Because we're choosing the jury the day you come back, we're also sequestering the jury that day. So you will need to have packed a suitcase for sequestration in case you're picked. Leave it in your car. Don't bring it into the courthouse. We'll retrieve it if you're chosen for the jury. Do you have any questions?
So is it my understanding I should be coming with a packed bag? Is that my understanding?
You should be packed and ready to be chosen as a juror, because if you're chosen as a juror, you're being sequestered and you're going to a hotel. Okay? All right. Thank you. And once again, we're behind schedule. All right. Anybody need a break, including the court reporter? We have the 10:30s here, but anybody need a break? What? We're missing 2 10:30s? Did the 2 9 o'clocks arrive? Oh, so see, we're back up to 10. Juror number 9 is missing. And who else is missing? Okay. C12 is what? Does he think that will stop me from hunting him down? Because it won't. All right. All right, folks, take a 10-minute break while we